Right, panel 2. I now welcome Michael Matheson, Cabinet Secretary for Justice, Scottish Government officials from Police Division, Ian Kernahan and Graham Waugh. And Cabinet Secretary, you wish to make an opening statement?
Convener, I'm happy just to go straight to questions.
Thank you. Oh, I like the sound of that. Roddy, Elaine, Rod.
Morning, Cabinet Secretary. Could
Morning.
you perhaps start by outlining the kind of formal relationship between ICOCO and the Scottish ministers?
Well, IOCO is a reserve body which is accountable and reports to the Prime Minister. Scottish ministers have got no direct control over IOCO or its function because it's set out within the Regulation for Investigatory Powers Act 2000, and any reports from IOCO regarding investigations into public bodies go directly to those public bodies rather than to Scottish ministers, or they would go to the Prime Minister. So there's no direct accountability as such or authority in Scottish ministers over IOCO and how it functions.
How do you feel about that? Do you think that's satisfactory?
Well, I think there's always room for improvement. I would certainly like to see improvement around this. So, for example, if there was any Scottish public body being investigated by IOCO into a matter, I think it would be reasonable for Scottish ministers to be notified of that, so that we were aware of that taking place. As it stands at the present moment, that doesn't happen. I think it would be better if there was an automatic notification of Scottish ministers. I also think it would be useful that where there is an investigation into a Scottish public body by IOCO, and that they have completed an inspection report of that particular public body, that too should also be provided to Scottish ministers as it stands. The committee will be aware that the UK Government are planning to revise the Regulation for Investigatory Powers Act next year, and part of that will also involve changes to the Commissioner role. So, for example, the Office of the Surveillance Commissioner, and the proposal is that the Office of the Surveillance Commissioner and the IOCO role come into one, and having one single oversight commission. I think it would be helpful at that particular point if we had a situation where in legislation there was a clear line through the new Commission to Scottish ministers to report on any matters relating to devolved bodies that are responsible for functions under this area of reserve legislation.
If I can turn perhaps to IOCO's reports. In the previous section I referred to a February 2015 report from IOCO. I don't know if you're able to help the committee in advising whether a copy of that was supplied to Scottish ministers, or when was your first kind of communication in relation to these matters?
We didn't receive an advance copy of the report. I understand that report went to the Home Office, but my understanding though is that that report is in the public domain now, so which is available. That refers to the work that was undertaken by IOCO in October 2014 and then published in February of this year, which resulted in the Code of Practice that was introduced on the 25th of March. So, but my understanding is that report's in the public domain now, but it didn't come to Scottish ministers in advance.
So can you help the committee by saying when you first became aware of the Code of Practice, and then in turn of a possible breach of it?
Well, both the Code of Practice and when it was breached. Is that the question?
Well, potentially two questions. Okay.
Yeah. So we were made aware of the intention for a Code of Practice by Home Office ministers at the end of February of this year, and their intention that the Code of Practice would be introduced in February. It's worth keeping in mind, and I noticed in some of the exchanges earlier on, individuals were referring to changes in legislation. There has been no legislative change. This is a Code of Practice. The reason it was introduced as a Code of Practice is because there was no time available at Westminster in order to introduce it through legislation. My understanding is that the Home Office intend that in the changes to the Regulation Investigatory Powers legislation is to put the statutory provisions which exist in the existing Code of Practice into the legislation, so it's got a statutory footing. for future reference. But that's, as I say, we were advised at the end of February that it would begin introduced in March of this year. And we were made aware of the breaches of this at the beginning of July of this year. And I was then formally given a briefing in this matter by ACC Nicholson in July, I think it was the 15th, on this particular matter and the full extent of the issue.
And can you tell us about that briefing?
Yeah, it was primarily from part of which you already know. IOCO had undertaken an inspection of Police Scotland between the 15th and 17th of June. During the course of that, they'd identified areas where there were breaches in the Code of Practice that had come in March. They had relayed that information to Police Scotland, and that Police Scotland were now undertaking a review as a result of those findings, which would then be submitted to IOCO. And that review was then submitted to IOCO at the beginning of August of this year. My primary concern was to make sure that Police Scotland were cooperating with IOCO in any breaches which they had identified, that matter was being looked at in detail, which they confirmed, which was part of the review work which they were undertaking for IOCO, and also that they would then address the deficiencies that had resulted in these breaches occurring in the first place. And they confirmed that once the review had been completed, they would then be in the process of looking at establishing an action plan in order to address these issues. What we also did in the interim was to contact IOCO to confirm with them that Police Scotland were cooperating and working with them on the issues that they'd identified, which they confirmed, and also that once the review had been completed, that the appropriate action plan would then be taken forward in order to prevent these breaches from occurring in the first place.
You were asked in Parliament on a number of occasions, I think, to confirm whether or not Police Scotland was one of the forces that have been referred to in ICOCO, but you refused to provide that information. Could you just clarify for the committee's benefit why you took that view?
Well, the context of this is that Police Scotland are no different to any other police force in the UK on the governance and oversight of the use of this legislation for the purposes for which it's intended. And that's IOCO's responsibility in order to undertake that oversight and the accountability role that goes alongside that. They identified in their interim report in mid-July that there were two forces in the UK which they were investigating in relation to possible breaches of the code. That understandably generated interest around whether Police Scotland was one of them or not. IOCO's view was that given that that was an ongoing investigation and given that they were continuing to look into the issue, it wouldn't be appropriate for them to name any of the forces who were involved in those investigations. And we accepted and respected IOCO's position on this. They set out themselves in their own public statement as to why it wouldn't be appropriate to name those individual forces on the basis of the nature of investigation, potential implications it could have for any further work which they were undertaking, and also for the individuals who may have been affected by any breaches. And we respected the position that they'd set out, and the view we came to was that they should continue to undertake the role on the basis of the basis on which they had set out. That it should that those two forces should not be identified while they were completing their investigation process.
Thank you. And what do you see the role of HMICS and SPA in this matter? The Special Police Authority.
Well, I think we've got to distinguish two different things here. Is that my understanding is that HMICS will not be undertaking a review of the investigatory powers area that's the responsibility of IOCO, who have got oversight and responsibility for that area. What the HMICS will be responsible for looking at is the procedures and processes around the counter-corruption unit within Police Scotland, and to look at how robust those are. It will be, as I've said to Parliament, it will be an in-depth, thorough an independent review of those processes, and that the terms of reference for that particular review work is presently being finalised by HMICS in coordination with IOCO, so that it doesn't go over their area of responsibility, and with the SPA before they finalise the heads of agreement on that particular investigation.
And the Scottish Police Authority's role?
It will report to, it's the Scottish Police Authority who have requested this by HMICS, and HMICS have agreed to it, and it will then be they will then report to the Scottish Police Authority, and as is always the case with HMICS reports, there will also be a copy laid in Parliament.
Okay. I'll let other members in.
Yeah, well, it's very kind of you to give me tell me my place. I'll now let other members in. That's you down at the bottom of the list next time. Elaine, followed by Gill, please.
Thank you, Convener. Cabinet Secretary, just for clarification, when did you personally first become aware that Police Scotland might have breached the IOCO new code? When did that come to your attention?
It would have been around the 10th of July, and then I was provided with a formal briefing by Police Scotland on the 15th of July by ACC at Nicholson.
Yeah. So what action did you take at that point?
What I've just set out was to seek their assurance that they were complying with the investigation that had been undertaken by IOCO, which they confirmed they were. That they had identified why there had been deficiencies in their process. They were undertaking the review as a result of the findings from IOCO at that particular point into this issue. That work was then being taken forward over the course of July and was submitted to IOCO at the beginning of August by Police Scotland. So that process has already started and was being taken forward. The second thing I was keen to ensure was that action was taken to prevent this type of thing from occurring again in the future. And part of that was for Police Scotland to take forward an action plan in order to address that. That was progressed following the review work which Police Scotland had submitted to IOCO and their findings from their inspection. And we also contacted IOCO to make sure that work was being progressed, and they confirmed that was the case in terms of Police Scotland cooperating with them, and also the review which Police Scotland are now internally undertaking as a result of the issues that had been identified by IOCO.
Have you had sight of the action plan that Police Scotland have?
I have had sight of the action plan, yes.
And you're satisfied that it's...
I'm satisfied with it, and IOCO are satisfied with it as well. As I said in their own public statement, it's a robust range of measures which Police Scotland have put in place in order to prevent this type of thing from happening again in the first place. And I'm satisfied that they have changed the arrangements in order to prevent something like this from happening again in the future.
When I posed that question to the Scottish Police Authority about action they took, it appeared basically the SPA hadn't taken any action. They sat back and said it's a matter for IOCO. As the organisation which the legislation passed by this Parliament scrutinises Police Scotland, were you surprised that they didn't? That Police Scotland, that the SPA wasn't more proactive in terms of Police Scotland didn't ask any questions?
Well, my understanding is that the SP were provided with a briefing by Police Scotland on this issue at the beginning of July as well, so that they were aware of the findings, or the initial findings from IOCO's review of Police Scotland's procedures in this area. It is worth keeping in mind, though, the statutory responsibility for oversight in this area lies with IOCO. That's based in statute. That is their responsibility. And there is an issue about the SPA having oversight in an area which is out with their control.
But equally, the Police Scotland has not had a particularly easy year with a number of different issues coming up, and would you not expect SPA to be a bit more concerned that yet again there was bad publicity around Police Scotland?
Well, I've no doubt they'd be concerned, but the point I'm making is that in terms of oversight, responsibility for oversight in this area of legislation is with IOCO. It's the exact same for Police Scotland as it is for any other police force or any other public body in Scotland. in these issues. So what happens in Police Scotland is no different to what happens in any other police force in the UK, with IOCO having responsibility for this area. Now, I do think it's important, though, that there are lessons that I think can be learned from this, and the actions by the SPA to request the HMICS to undertake a review of some of the procedures and practices within the counter-corruption unit, I think is useful, and I would fully expect, if there are any findings from the HMICS review in this area, for the SPA to then pursue these matters with Police Scotland and to ensure that they are appropriately and fully implemented.
IOCO said that the actions of Police Scotland had been reckless. I wonder, could you say what you understand by the definition of the term reckless? I mean, it's used in legislation, it's in the Abusive Behaviour and Sexual Harm Bill, which we're having to postpone. What do you understand is the definition of the term reckless?
Well, I suppose in terms of the definition, you'd have to put that to IOCO, who've obviously made the determination on that basis. There are essentially two levels, I believe, that IOCO can make a determination to say it's whether it's willful or whether it's reckless. In this case, having considered the matter, they've decided that the issue was reckless. There was the distinction being there was no deliberate act on the part of officers within Police Scotland to willfully not apply the code in itself, but they have been reckless in failing to actually apply it in the way in which it was intended, which could have had an impact on individuals who are affected by that. But the final definition around the determination is a matter you would have to pursue with IOCO, given it is their responsibility to come to these determinations.
DCC Richardson seemed to imply that the definition was in some way confidential. Does that surprise you?
Well, again, that would be it would be for IOCO to explain that to you if they do not intend to explain how they have come to that particular definition. But my understanding is that the marked difference between it being willful and reckless is that there was no deliberate attempt. And in fairness, IOCO have stated that as well. And Police Scotland have made that clear in their own statement following this investigation, that there was no deliberate attempt for them not to apply the code. But clearly an error has been made by an officer who I've got no doubt was trying to do his best in relation to the matter, but the code has not been properly applied in this instance.
But there is there's an understanding in Scots law what reckless means because we use it in legislation, is it not? I mean, do you think that's different? There's a difference that somehow reckless and the IOCO's definition of reckless is somehow not as rigorous as our definition of reckless?
Well, I don't really want to preempt IOCO's explanation of their definition. You would have to pursue that specifically with IOCO, given that it is their definition and their determination.
Gill, please, followed by Margaret Mitchell.
Good morning, Minister. We heard that some of this came about because there was a push for the timeline to come in early. And I wondered what comments you would like to make to that, and was the Scottish Government involved in this push for this to take place quicker?
Well, and the timeline relates into the work which was commissioned by IOCO around the way in which the police were obtaining communication data relating to journalistic sources, which started in October the year before, in 2014, which then reported to the, as I say, I believe it was to the Home Office in February of this year. The timetable for its introduction was a matter for the Home Office. There were concerns expressed around the speed at which it had been introduced, and I believe that the Commissioner himself, Sir Anthony May, had raised some concerns about that. But I also recognise there was a desire to make sure that this issue was addressed, I suspect, largely prior to the dissolution of the Westminster Parliament, so that arrangements were in place for any requests which were made by the police for this type of communication data to be obtained. So I suspect that was probably one of the biggest factors that had an influence in this issue. Having said that, that may have led to some of the challenges which have been presented, but notwithstanding that, IOCO have identified where there have been deficiencies, and it's important that they're appropriately addressed, and actions taken to prevent it from happening again in the future.
And since, and you pointed out yourself, Minister, that this is a code of practice rather than statutory, the fact that it was a code of practice, could it have been the case that a decision could have been taken here in Scotland to slow this process up, recognising, or again, is it in hindsight just because we know what's happened now and because of shortage of time, some of these things have happened?
No, we couldn't have delayed it because it's a reserved area. It's an area of reserved legislation. The code of practice was taken forward by the Home Office. So it wasn't an area we were in a position where we could have decided to take a different approach in Scotland. This applied to all forces across the UK, and the time frame was set by the Home Office.
So the pressures were UK-wide, were they? Yeah.
It was for all forces across the UK are covered by this legislation. So, but we weren't in a position where we could say that this would not apply in Scotland because it was an area that was out with their competence. And finally, has IOCO been investigating any other Scottish public bodies this year or in previous years? And if so, how many? You might be aware of. I know your limitations because it's reserved, but I'm not aware of them. Well, they obviously undertake their annual review process of public bodies that have powers under the Regulation for Investigatory Powers Act. But I'm not aware of them having findings against any other public body in these areas. I would expect, as from any inspection process, areas where bodies can always make improvements, but they have not flagged up to Scottish ministers any concerns about any specific public body that around how they're applying Regulation for Investigatory Powers legislation or its guidance. Having said that, back to my earlier comment, they would not normally notify us of these matters anyway, because these are matters which are reserved, and they would not necessarily direct any information to Scottish ministers in these instances in the first place.
Even although they are reserved, Minister, do you think it would just be common courtesy to inform the Scottish ministers in that regard, even if it was not to take any action, but just to keep you posted? Or does that take place? Do they keep you posted and it's off the record, or in a way that you're not able to act on it?
It's off the record, and the Cabinet Secretary admits it's on the record. So.
Well, neither on the record or off the record.
I was actually meaning informal.
Look, this has been the position for successive governments in the Scottish Parliament. So, because this legislation has been in place since 2000 actually. I was actually on the Justice Committee when we dealt with the Regulation for Investigatory Powers.
We were
Scotland
there together,
Act.
Cabinet
So,
Secretary.
at the
How
time,
far you've come and how far I've fallen.
But as I've mentioned earlier on, I do think in revising this legislation and in looking at changes that can be made to it, one of the areas I do wish to pursue is the issue of making sure that Scottish ministers are notified of any concerns which IOCO have or its successor organisation have around any specific Scottish public bodies that have powers in this area of reserved legislation. I think that's a reasonable thing to expect, and also it provides ministers and to some degree Parliament with an assurance that there is a feedback into Scottish ministers around any areas of concern that have been raised by a Commissioner in relation to how a public body in Scotland may be operating in these areas.
Okay, thanks very much.
I'm just going to take people in order, Alison, because everybody's pretty well in the same thing. Margaret Mitchell, followed by Christian, followed by Alison, followed by Margaret McDougall.
Good morning, Cabinet Secretary.
Morning.
You've stated on a number of occasions, and again today, that the statutory oversight for the Code of Practice was reserved and it was IOCO's duty. We now have the findings from the investigation. Are there any of these findings, any areas of these findings that the Scottish Government have devolved competence over looking at?
In what way?
Well,
I'm
for
not entirely
example,
clear about what
we know
what the
there's
point is.
been a breach of Article 10, which is the freedom of the press article, and the implementation of the convention is a devolved issue. So what's the Scottish Government's reaction to that?
Well, if I understand your point correctly, there are no recommendations for Scottish Government in the IOCO report. But secondly, the area is an area of reserved legislation, and the Code of Practice is a matter which is reserved, and the oversight of it is reserved as well. The action plan that has been developed by Police Scotland following their own review of the matter, given the initial findings from IOCO. IOCO then conducted their further detailed investigation following the review which they received from Police Scotland in August of this year. And during that period of time, Police Scotland developed their action plan to address the issues that had been highlighted and shared that with IOCO to seek their assurance that the changes which they were making would address the concerns and issues that IOCO had, and to prevent a breach like this happening again in the future. IOCO have now stated, yes, they have put robust measures in place in order to prevent this from happening again in the future. So we have assurance from IOCO, and from what I saw from the action plan as well, that Police Scotland have taken forward a range of different measures to prevent something like this from happening again in the future.
So even though the Scottish Government has responsibility for the implementation of the convention, and there has been a breach of one of the articles, Article 10, then the government has no responsibility or does nothing else to follow up on that, given they have devolved competence for the implementation of the convention.
I'm not entirely sure of the logic of this, but the issue around, yes, there is Article 8 and Article 10 are issues, I believe, that relate to some aspects around this. However, the oversight and the legislation it relates to are reserved areas, and the action which is being taken has been agreed that it is the appropriate measures in order to prevent this from happening again in the future. I'm not entirely sure what else you would expect the Scottish Government to do.
Well, I suppose just look round the whole implementation of Article 10 and see if there's anything within the organisation, because I think the committee is very frustrated. The SPA never seem to be hands-on, and we always have another assurance review and never seem to have too much teeth. So if there's an implementation of human rights aspect, I'm merely checking that the Scottish Government is quite confident in its own mind and you in your mind that you've done everything possible to make sure there aren't any breaches of these articles, which we have devolved confidence in a kind of wider view of what's going on in Police Scotland. Now that this has been highlighted, and it is a very, very serious issue, as I'm sure you'll appreciate, freedom of speech in any democratic society is absolutely fundamental.
I'm mindful that some people would like to abolish the Human Rights Act and remove it from their statute. So,
perhaps they would like it to be implemented better than it's currently being implemented.
That's a different debate then, yes. Not the one that I'm familiar with, but from the Conservative government at Westminster. But what I can say is that obviously issues around ECHR were considered by IOCO during the course of their investigation, and they've said that robust measures have now been put in place to prevent this from happening again in the future. I'm confident, given IOCO's expertise in this area and knowledge in this area, that those robust measures are now in place. And having considered the action plan as well, I'm confident that they've put the right measures in place as well. But the member will also be aware that one of the outcomes from an investigation like this is that that there is the possibility of an investigative powers tribunal which can consider these issues further and can consider the extent of the impact it's had on individuals who were affected by this. You know, I'm aware from the media there's already one party has indicated that they would intend to take it to a tribunal. They are then in a position to look at this in more detail on how it's affected that individual, and also to look at whether there's any further measures that then need to be taken as a result. So that's a process that's still to be gone through by those individuals who do believe that their rights have been infringed, and they've been notified of that by IOCO, and IOCO then have a responsibility in making sure that they're furnished with sufficient information for the purposes of then taking forward any case to the Investigative Powers Tribunal, which again is a reserved area, which is part of the statutory provisions within this area of legislation.
I think you've answered my question, Cabinet Secretary.
Well, Christian, followed by Alison, please.
Good afternoon, Cabinet Secretary. Just a point of details, just to clarify, I may be misunderstood, but were you made aware of the change of the code of practice?
We were made aware of the intention to introduce the code of practice towards the end of February this year. I had a discussion with the Home Office Minister, James Brokenshire, who was responsible for taking forward this area within the Home Office.
Did you discuss the implication that a quick implementation will maybe be a problem? Did you forecast in your discussion of any problem that could arise because it was not enshrined in legislation, but it was only a change of code of practice?
Well, part of the challenge here was the issue I was referring to earlier on was that there was no time at Westminster for them to put this on a statutory footing, and they were also mindful that they were intending to look at in post-elections in the new Parliament changes to the investigative powers legislation, which the committee will be familiar with. The UK government have already set out the plan to take forward, and that the most practical way in which to deal with it at this time would be through a code of practice. So clearly there was pressure in Westminster's timetable because of the pending general election which was coming forward, and there would be challenges in its implementation, and that was a challenge which no doubt the Home Office were aware of, but also it was highlighted by the Commissioner himself. But the decision was to make the Code of Practice available and to put it in place prior to the dissolution of the Westminster Parliament.
Thank you.
And Alison, followed by Margaret McDougall.
Thank you. Cabinet Secretary, you'd agree, though, that the urgency, if I recall, at Westminster at that time was precisely to protect journalists following attacks on press freedom. So there was an urgent need to do something.
Oh, I do recognise that, and it would be wrong to suggest that we were opposed to this. We welcomed the Code of Practice, and we actually believe it should be put in a statutory footing rather than as it stands as a Code of Practice.
That's a helpful clarification, thank you. This morning, DCC Richardson sought to excuse the breaches of the Code of Practice by saying that and I think I quote, the pace was aggressive and pressured in introducing the guidelines. Would you agree with me that if the DCC was so concerned about that, it would have been reasonable to expect them to have sought to make representations about that, or to ask you to make representations to Westminster about that?
Well, you know, I think it is fair to say that it was a very tight time frame to introduce this Code of Practice, and there's no doubt there have been some challenges, and part of this may be the most recent findings from IOCO may be in part as a result of some of that timetable. But I'm also conscious that forces across the UK all had to apply the same rigour to this particular issue. I think there were some challenges around guidance being provided to the police through the Home Office and also through IOCO. So, for example, in one area in the timeline, and looking at this, which may be of interest to the committee, and obviously in pursuing these issues with IOCO as well, is that the IOCO published its guidance on the independence of the designated person at the beginning of June. So even with the code of practice coming into force as of the 15th of March, there was still a gap in the provision of some of the guidance, which was then being passed on to the police and to other public bodies and other organisations who have pillars in this area. So I think it may have contributed to some of the challenges in these areas, and I think it is reasonable for Neil Richardson to highlight some of the challenges that would create for them at that particular point.
Yeah, thank you. Police Scotland on a number of occasions have had less regard than I would like them to have to human rights compliance, and I think about what we've had to do in relation to stop and search, and we've got this. So are you comfortable and satisfied that Police Scotland has the necessary expertise within the organisation to fully comply with ECHR, or do you feel that we need to review what's available to them?
Do you mean in terms of legal expertise within the organisation in understanding ECHR?
Are they being properly advised and then able to roll that out through the organisation so that it permeates everything that they do, to be honest?
Well, look, Police Scotland have to be compliant with ECHR in the same way that any other public body in Scotland has to be. And in this particular instance, a mistake has clearly been made by, as you've heard from Neil Richardson this morning, a very experienced officer with a considerable level of expertise in this area. But a mistake has been made, and we need to ensure that lessons are learned from that and to prevent it from occurring again in the future. I'm very conscious that as part of police training and part of their ongoing work is that they are regularly refreshed and advised around human rights issues and implications of these issues, and to make sure that the approaches which they're taking are compliant with these areas in legislation. I've been at briefings within Police Scotland where officers are going out on particular operations where that's been reiterated to them. So I don't think there's I think there is a strong recognition within Police Scotland is that they need to be compliant with ECHR, and that they shouldn't be acting in a way which compromises that. But clearly, in this particular case, there have been deficiencies which have resulted in the wrong judgment being made. But again, I would go back to the point from IOCO in that it wasn't willful, it wasn't a deliberate act in order to misuse the legislation or to deliberately ignore the codes of practice.
Thank you very much. Margaret McDougall, followed by John.
Thank you, and good afternoon.
Afternoon.
I want to ask a question around this judicial approval, and it's in the Code of Practice where the police request communications of a journalist's source. Is that a new requirement?
For the judicial approval?
Uh-huh.
Yes, it is.
Yes. Right.
So prior to the Code of Practice coming into force, there was no judicial oversight of it. The Code of Practice introduced a judicial oversight. There are two key areas that the new Code of Practice introduced. One was the provision of the designated person in authorising a request for this type of communication data. And the second part was judicial oversight in that, around journalistic sources. So the Code of Practice was introducing new provisions in order to provide stronger safeguards in this area, because the report that IOCO had started in October 2014 was specifically looking around this issue, around how the police were using these measures when it came to journalistic sources. And the two key parts of the Code of Practice are the designated person and also the judicial oversight.
And this was in March that this Code of Practice came out?
25th of March it came into force.
So you would expect an officer with the expertise that we've heard that Detective Superintendent Davison had, that Donaldson, the
the 2 points that you've just pointed out, that he would have picked up on that the main differences are, and that he would have been able to identify that he needed judicial approval to look into that.
Well, as you've heard from Neil Richardson this morning, their explanation as to how that's not come about, in that the officer who was dealing with it's taken a very narrow view of the request rather than considering some of the wider issues, which resulted in them coming to a judgment which meant that the code of practice has not been applied in the way in which it should have. And the oversight function through IOCO, through their inspection of Police Scotland, has identified the deficiency and asked them to review that matter, and for them then to put appropriate measures in place to prevent it from occurring again in the future. So I think Neil Richardson's better placed than I, from an operational point of view, to explain the process that the police use in taking these matters forward. But clearly, an error has been made, and that in these cases, judicial oversight of the decision should have taken place.
Thank you. If I could just move on to that, the action plan, which was a result of the review, had 12 points on it, and all of the 11 action plan points have been executed, as far as I know, except for the one on judicial reviews and approval. Is that not of concern to yourself, given that, you know, that was the issue?
My understanding is that Police Scotland are already in the process of putting in place the right judicial process for that.
That's what you told us this morning.
Yeah, they're in the process of putting in place the formal process to ensure that that happens, that mechanism is available to them for any future decisions in these areas.
But
so it's not a case of that they're not doing it. It's in the process of resolving that area identified within their action plan.
So it's not implemented if it's not resolved?
Well, they're working to implement it just now.
I think just as a point of information, Margaret, the updated Code of Practice now requires the police to seek judicial approval in such circumstances. So it's not a review, it's just, I think you mentioned.
No, but in the action plan that we spoke about earlier, one of the points was that around the judicial approval, and I forget the title, Mr. Richardson, who was here this morning, he said that they had all been implemented apart from the one around judicial implementation.
They're in the process of taking forward that particular action point within their plan. It's clearly in Police Scotland's interest to make sure that that is addressed, because if they don't have that, then they won't be in a position where, if they deem it necessary to look at obtaining communication data, and it relates to the provisions within the Code of Practice, then they will have to have the judicial authorisation process.
So I think the point I was trying to make is that it's not discretionary, it's mandatory. They've got to, if these other tests apply.
Of course. They will have no choice.
They haven't exercised it yet. It's not complete as far as their action plan is. That's the point I'm making. So we don't have that as yet.
Well, we'll leave it at that just now. John?
Cabinet Secretary. Cabinet Secretary, you've laid out a very clear timeline of the Scottish Government's engagement on this particular issue, and I'm grateful for that. We heard a less than clear position put forward by Mr. Richardson. Maybe that clarity will come with all the various follow-up notes he's going to give us. You've commented frequently about statutory oversight, and I think we all understand that the role there is for that. Once again, the police authority look like bystanders. They look like onlookers to a process always playing catch-up. We're told that in August of this year they received a briefing from Police Scotland, and 3 or 4 months later they institute an assurance, yet another. And I hope Mr. Penman's getting additional resources for all this additional work he's doing, because he's A perennial, yeah. I'm sure you'll have them in mind. But there is a very serious issue here, and that is, I wonder what role you see for the police authority. They're effectively making themselves redundant. When they do become involved, it's playing catch-up. It's calling on the good services of Mr Penman and his staff, and I think we should all be grateful for the diligent work they've done in relation to stop and search and armed policing and the rest. Are they doing themselves out a job?
No, I don't agree with that. Are there areas for improvement? Of course there are. Are there ways in which the Scottish Police Authority can ensure that they are undertaking robust and challenging oversight of the way in which Police Scotland are operating, to identify areas where they believe that improvements could be made? And the SPA do a range of that, but there's always room for improvement. I don't think the SPA would say there is not room for improvement as well. But I don't want to, I think it is worth, though, reiterating the point is that oversight in this area does, on a statutory basis, lie with IOCO in the same way that it does for every other police force in the UK. And I think there is room for improvement around how IOCO engages with some of the oversight bodies that may have a role around policing in general, and how that they share information with them. So, notwithstanding your own view in the matter about the need for the SPA to try and get ahead of the curve, which is what I presume your central point is, I think it is worth keeping in mind that the statutory oversight in this area is the responsibility of IOCO, in the same way it is for every other police force in the UK.
Yes, appreciate it's a reserved matter, and I know you're not suggesting total disengagement, but we also have other groups. We have the Information Commissioner, the Surveillance Commissioner, and perhaps most importantly, more locally, PERC. It must be that there's a bit of proactivity that's required of the police authority. This committee can do it, the subcommittee on policing can do it. They have been behind the curve on every major issue.
Well, there are, as I've already mentioned, there is areas for improvement, and we have a new chair in place who's undertaking the governance review at this present moment, which will report in the spring of next year, to look at how we can improve governance more effectively around certain policing matters. And I'm keen to make sure that we make progress in that area as well. So there's, I think over the last 2, almost 3 years now, now is a good time for us to look at how we can improve the governance process and the oversight process, and that work has already been undertaken. But I do think it's also important, though, that we don't lose sight of who does have the statutory oversight in this particular area, given that that's what we're considering here today, and the way in which that operates. And I do think, given the type of architecture we now have in Scotland around policing and the oversight of policing and the way in which it operates, I think the changes that are made to the Commissioner's role around the regulation of investigatory powers gives us an opportunity for that better to reflect that changing relationship and the different type of architecture we now have in place for oversight of policing in Scotland.
Thank you very much.
Much of this Cabinet Secretary takes place against the backcloth of the Emma Caldwell murder and accelerating the case again. It was interesting that the Procurator Fiscal wrote to Police Scotland on the 25th of May 2015 to tell them to accelerate matters. I haven't seen the letter. While I respect the independence of government from the prosecution service, do you know anything about that letter?
You need to pursue that matter with the Crown Office
so you don't know anything about that
directly.
Yes. I raise this because of while we're talking about process here, I think as a background is what was really this all about at the end of the day. The questions arise about Police Scotland reads things in the paper, who's leaking this? They do stuff. We must accept that the IOCC say it wasn't willful but was reckless, but it's not happening in a vacuum. And then in the middle of all this, the investigation into this historic murder case takes a step up. And that's just what I'm wondering about where this all comes into, but you're not in any part aware of any of that.
Well, it is a live investigation, and you know, it wouldn't be appropriate for ministers to start commenting on a live investigation, but you would have to, in order to explore further the Crown Office's views on these matters, you would have to pursue that directly with them.
Right, that's fine. Thank you very much. Thank you. And thank you for your evidence. Do you have no other questions? I'll suspend for a couple of minutes.